Check one, mic test, check one. Who is that saying shh? Check one, mic test, check one. Tuko sawa?
My name is Stanley Kinyanjui, and I'm an advocate of the High Court. We were in court some while back, whereby representing the family of Sarah Kathambi Igweta, where we had moved to court, or rather where she had been sued for the burial, or rather the release of the body of one Silas Igweta. And the person who had moved the court was the first wife, that is Grace Rigiri Silas. And the court, through its judgment, delivered sometime last week on Thursday, held that the person who was most close to the late Silas Igweta was the one who was supposed to bury him. And we welcome this judgment because it is an advancement of what we've been advocating for in terms of burial disputes. As you may be aware, there is no particular law in this country that gives a procedure or gives a substantial law that governs the disputes that arise out of burials. But we can see the court borrowed much heavily from the recent case of the Ontwekas, whereby the court, in its own wisdom, decided that in as much as there ought to be some level, or rather some degree of the people who are supposed to claim the body of a deceased upon his or her death, there are also some other extraneous circumstances that would also involve, or rather invoke, the court to assist it in making a just decision. And one of those circumstances, or rather one of those factors, is the decision, or rather making a finding as to who was the most close to that deceased person. And I believe that that is progressive jurisprudence. And with time, we are going to move away from what has been a muddy place when it comes to the law that governs burial disputes, so that in as much as it is not clear-cut, but at least we have a guiding light and guiding principles as to how the body of a deceased person should be buried. And thank you.
Now, on the 17th day of February 2024, the family of the late Silas Igweta, and the family of Sarah Kathambi lost their father, lost their husband, and subsequent to that, there was a number of suspicion. There was a suspicion which came from the first family, the family of Grace, which suspected that the family of Sarah Kathambi had murdered their husband or murdered their father. So for that reason, the body of the late Silas Igweta, a man who has served the great people of Meru for so many years, a man who has lived lived his purpose on this earth, a man who died at the age of almost 100 years, was subjected to a post-mortem procedure which revealed to the family the cause of the death of their father or the husband of Sarah Kathambi. So it was revealed to us that indeed he did not die out of, a natural means, but he died out of a natural cause, which caused his death. And for that reason, the family was ready to inter his remains. But lo and behold, when the family of the late Silas was preparing to inter his remains, this family, who are gathered here with us, received a court order that prohibited, or rather restricted, the burial of the late Silas Igweta, which now resulted to court proceedings, which terminated last week on the 27th day of March 2024. Now, in the judgment that was read by Honorable Gitonga, seated in the commercial division of the Magistracy Court here in Milimani Law Courts, the court returned a verdict, which, of course, gives impetus, gives a lot of strength to what is now called the sepulchral rights, which are rights of mourning, rights that are very new to the current constitutional dispensation. Remember, as Mr. Stanley Kinyanjui has mentioned, the current constitutional dispensation does not tell us what should happen to the remains of a dead body. It is left to the judicial discretion. It is left to the judges and magistrates deciding on a case-by-case basis. And now what the court decided is, in view of the fact that it was deponed, it was sworn by the people who had sued this family, that of Grace Silas, that, number one, the family considered that they had already sold the ancestral land. And for that reason, they will not, in their other mouth, claim that they want to bury the deceased in the ancestral land, which was not there, which had already been sold, so that the family will educate some of his children. That is number one. Number two, the court, breathing life to these sepulchral rights, decided in one accord that indeed it is important to mention that the person who has lived, or the person who has enjoyed, the comfort and lived together with the deceased for the period of time this deceased was alive, and perhaps even before his death, that was now Sarah Kadhambi. And for that reason, the court decided that Sarah Kadhambi should be given the remains of the deceased so that he can go and bury, together with the family of the first family. But now, after the decision was rendered, it is unfortunate. And this is where we cry with the first family. We urge the first family to reconsider. The first family made an application to have the orders of the court stayed for a period of 14 days. So at this point in time, we want, through this press briefing, to urge the family, the other family, which has not been, they have not been secluded, or there is no plan to separate, or rather to seclude them from the burial preparations. We urge them to reconsider their position of the appeal. I mean, this is someone who has lived for the past a century. It is high time that we decide, or they decide as a family, to inter peacefully the remains of Silas Kamuta Igweta in one piece. So that should be all from my part. I'll pave the floor for my senior, Mr. Danstan Omari, who is going to also share his nuggets of wisdom. Thank you.
The person we were fighting over, his dead body, is a Meru, the first Meru person to be an engineer, the first Meru person to buy a car, the first Meru person to build a permanent house, the first Meru person to have a Mzungu kak suit, the first Meru person to have stopped his daughters from being circumcised, the first Meru person to have taken daughters to school, the first Meru person who inspired everybody. So the argument that was in court was about this man. And the question was, he had married in 1957 in a church function. Again, he married in a traditional manner. So the question was, under the current law, anybody who has a marriage certificate has an automatic right to bury the deceased. We presented before the court that for 40 years, he had moved away from that marriage of a marriage certificate. We put this question to the court. Is marriage, what are the vows of marriage? The vows of marriage are till death do us part. Can anybody claim to be married to a corpse? There was no marriage. And the court agreed with us that the marriage was for the purpose of being a wife or being a husband. Those terms have disappeared. Upon death, she becomes a widow he becomes a widower. So the court agreed to us that this traditional concept about I was married does not move after death. The second question that was there is who will be given the right to bury? The court has settled that the person who has been very close to the late person. That is the jurisprudence that has come. And this is a landmark jurisprudence because a man walked away 40 years ago, alive. He's being driven in a casket to be buried, where he ran away and he never looked back. So, as Shadrach has said, it is a landmark decision. Probably it will move still to the Court of Appeal, but we are urging that this matter comes to an end. Let the first Meru man be there. The other question that was there was the traditional aspect. Did this man live as a traditional Meru person? The court found out no. He was not Anjurinjeke. He was educating his daughters. He had one time married these women and kept them in one house, one bedroom, for over 3 years. That is not a traditional man. So the court agreed that modernity has captured even the Meru customs, and people now will be buried based on the modern Christian aspect other than the traditional marriage. Thank you very much.